Some good news coming out of the Supreme Court, an important decision limiting the reach of the Environmental Protection Agency, or the EPA. And, these regulatory agencies have enormous power. You build an extension to your house and they come and say, basically, you got to take that down because, hey, it's adjoining a pond that we have classified as a wetland. And so this now comes under environmental protection. You need permits to be able to do this construction, even though it is on land that you purchased. Why? Because the land is adjacent to or adjoining land that we claim, we meaning the US government claims, is under special environmental protection. So this is how the EPA throws its weight around. Now, the Supreme Court in a 6-3 ruling last June kind of whacked down the EPA on the Clean Air Act. That was an important decision involving greenhouse emissions from coal and gas-fired plants. But the EPA, of course, they've got not just that, they've also not just got the Clean Air Act, but they also have the Clean Water Act. The Clean Water Act of 1972. Now, here's what the case was about. Basically, a couple named the Sacketts, S-A-C-K-E-T-T, they bought some property and they were building on that property. And the EPA shows up and says, you can't do it. Why? Because your property is adjoining or adjacent to a wetland. And so this goes to the court. Court decides in favor of the EPA. It's appealed up, goes all the way to the Supreme Court. And the EPA is basically saying that that this couple cannot do what it wants with its own property. And interestingly enough, the case hinges upon the meaning of the word adjacent. So adjacent means next to, attached to. And the issue is, if your property is adjacent to a wetland, are you covered ultimately by the EPA's rules governing the wetland? EPA says yes, Sacketts say no. Now, the Supreme Court decides, and this is what's really significant, the decision is 9-0. 9-0 against the EPA, which means that even the 3 liberal justices agree that the Sacketts should be able to build on their own property. And remember, this isn't just about this one couple and building on their property. The reason these cases go before the court is redefining the reach of the EPA. This is why the Biden people are screaming so loudly about this decision. And in fact, here's Biden. It puts our nation's wetlands and the rivers, streams, lakes, and ponds connected to them at risk of pollution and destruction, jeopardizing the sources of clean water that millions of American families, farmers, and businesses rely on. First of all, the Sacketts weren't doing anything of this kind. It's one thing if they were like dumping millions of pounds of sewage into a pond that somehow fed into, let's say, a lake or a river or even the ocean itself. But none of that is really even going on. These guys are trying to build on their own property. So Justice Alito basically goes, listen, the Clean Water Act extends to wetlands that are indistinguishable from the waters of the United States. So think about it. A wetland is a marsh or a pond, but it has to be part of the property of the US government. That's what they mean by the waters of the United States. And then he goes on to say the wetlands on the Sacketts property are distinguishable, which is to say separate from any possibly covered waters. And so here's the Supreme Court saying to the EPA, hey, listen, just because you have a delegated congressional administrative authority to regulate wetlands doesn't mean that you can lord it over the people of the United States and just decide, you know what, I think I'm going to call, Dinesh lives near a pond. I'm just going to call Dinesh's property a wetland. I'm going to show up. And remember, we are living in an age, and this is very disturbing, and not a lot of Americans even know this, where groups like the EPA and the post office have SWAT teams. They actually have people with guns who can show up to your property and essentially force you to do something. And it's all because of, not because you're a criminal, not because you even broke the law, but because you're going against an administrative regulation that they have passed for themselves, essentially giving themselves more power. Yeah, we made a rule the other day deciding this, and so you're in violation of rule number 3874. So I think what the Supreme Court is saying is, no, listen, wait a minute. The authority to regulate comes from Congress. Congress can delegate some administrative authority to the EPA. So, for example, you can regulate wetlands. But that doesn't mean you get to say what is a wetland. It means that a wetland covers a certain definition, and that's the waters of the United States and property adjacent to those waters. And it doesn't go beyond that. So ultimately here, I think the Supreme Court is being faithful, not just to the Constitution, but to the intent of the statute. The law itself, the Clean Water Act, as passed in 1972, didn't mean to classify the whole country or virtually the whole country as some sort of a wetland. No, the idea was a wetland is a wetland. And the EPA has its authority. It stretches pretty far. But now the Supreme Court has said no further.